then the first. Okay. So I'll start. Well, now you see 4 slides at once, so you always have a head start. That's good. In the second slide here, you see the 9 subjects that I put in for the lecture today. It's like I said, it's more a combination of a few lectures that I was trying to give and also gave beforehand. It's diplomatic protocol, Black Protocol. That's the first part. And then the international system, of course, United Nations, the role of international law, and then International Court of Justice and International Criminal Court. So how the implementation of international law. And then also a brief discussion about the Human Rights Council and the Human Rights Committee. I'll just go quickly to the third slide, which you already see on the screen. First, of course, it's important to have a few definitions about diplomatic protocol. So protocol is a rule on how an activity should be performed. It's very basic. That's what a protocol is. A diplomatic protocol is the official procedure or system of rules governing affairs of state or diplomatic occasions. And diplomacy is the profession, the activity or skill of managing international relations, which is typically done by a country's representative abroad, like an ambassador. In the fourth slide, if you, Dr. Abbey, if you quickly go up a bit, because then people can see it completely. It's the purpose of a diplomatic mission. So what's the purpose of a diplomatic mission? It has 5 main points. Firstly, the purpose is to represent the sending state in the receiving state. Secondly, it is to protect the interests of the sending country according to international law. The third purpose is to negotiate with the government of the receiving state. And fourthly, is to ascertain by all lawful means the conditions and developments in the receiving state and reporting about that to the government of the sending state. And lastly, of course, to promote friendly relations between the sending state and the receiving state and developing economic, cultural, and scientific relations. That's the fourth slide. It's a bit difficult to see maybe for you and also for me a bit. The diplomatic mission names. Of course, you're all familiar with the embassy, when a diplomatic is sent from one state to another state, for example, from the Netherlands to the United States, then it's called a permanent diplomatic mission. And the person who is in charge of that is called the permanent diplomatic representative. That's different from one state to an organization, like the United Nations. For example, then you have permanent mission. For example, you have the permanent mission of the Netherlands to the United Nations. And that person is then the permanent representative. So it's the same person, but not diplomatic. Also, something that's important to distinguish is what you sometimes hear is high commissioners. What is a high commission? Basically, a high commission is the permanent diplomatic mission from a Commonwealth country. And the Commonwealth is an international organization consisting of the United Kingdom and countries that were previously part of the British Empire. A high commissioner is the permanent diplomatic representative for Commonwealth countries, whereas embassies are permanent diplomatic missions sent from non-Commonwealth countries. And whereas the ambassador is then, of course, the permanent diplomatic representative for non-Commonwealth countries. And the next slide is about the consulate. Consulate, well, you probably know, it's a smaller version of an embassy. It's generally located in a large tourist city and not in the capital. The chief diplomat is a consul, and the consulate handles minor diplomatic issues like issuing visas, aiding in trade relationship, and taking care of migrants, tourists, tourists and expatriates. And in the next slide, you see an overview of the type of diplomatic missions. Now it's the next slide, please. Yeah, where you can see that the embassy is a diplomatic mission located in the capital city of another country, and it offers a full range of services. A high commission is an embassy of a Commonwealth country located in another Commonwealth country. And yeah, can you move a little bit up with the slides, please? Well, even further. Yeah. So yeah, I have listed here the type of diplomatic missions. So the embassy, the high commission, a permanent mission to an international organization, and a consulate. So those are basically the 4 types of diplomatic missions. Yeah. And then also just briefly, the diplomatic ranks within an embassy. The highest ranking person is an ambassador. And there you have, below that you have ministers, plenipotentiary, chargé d'affaires, minister, counselor, and secretaries. Those are the main ranks within an embassy. And then also very important for diplomacy is, of course, the Vienna Convention. Yeah, I see it now on the screen. Hello. Okay, I hope you can hear me. Yeah, it's the Vienna Convention on Diplomatic Relations of 1961. Well, it's an international treaty that defines a framework for diplomatic relations between independent countries. Its aim is to develop friendly relations amongst governments through a uniform set of practices and principles. Most notably, it codifies the long-standing custom of diplomatic immunity, in which diplomatic missions are granted privileges that enable diplomats to perform their functions without fear of coercion or harassment by the host country. The Vienna Convention is a cornerstone of modern international relations and international law, and is almost universally ratified and observed by all United Nations members. And then the Vienna Convention of 1963 deals with consular staff. I hope you can see this slide. Yeah, but so the Vienna Convention on Diplomatic Relations of 1961 is the international treaty that defines diplomatic relations between countries and international organizations. Okay, yeah, and then the next slide, I think you can see it, about diplomatic communication. Well, basically there are 2 types of diplomatic communication. Firstly, you have the note, which is a personal message between the head of a mission and the Minister of Foreign Affairs in the host country. It's usually written on the ambassador's official paper. This is private, so this message is a private message and is not available to the public. Then you have the note verbal, which is the public message. It's the communication between the Minister of Foreign Affairs and the embassy. And for diplomatic communication, it's also important to know that there are 6 official languages of the United Nations. We have Arabic, English, French, Chinese, Russian, and Spanish. Although the UN Secretariat uses English and French. But if someone wants to communicate in another language, then they need to bring their own interpreter who translates to one of these 6 languages. And then the following slide is about precedence, which is, of course, very important in diplomatic relations. Precedence means order based on rank. And it is one of the principles of protocol. Yeah, a protocol includes placing participants in appropriate seats according to their rank, title, or function at ceremonial events. I get a lot of messages to admit you, but okay, it's going to work. Yeah, and of course, in diplomacy here, a person is more or less important depending on his or her function. And it's always important to understand the principle of right-hand side. Well, right-hand side, basically the right-hand side. The guest of honor, so the ones that you are inviting, should always be on the right-hand side of the host. Yeah. And going further on precedence, so the order based on rank, precedence among states. What is of course very important, also what we learned in the previous lectures, is that all states are equal. So no state is above another state. So all states are sovereign and equal internationally. So how precedence is organized is it's organized alphabetically in English or French, or it's by drawing lots. And by drawing lots, then you take the first, then you put the letters of the alphabet in a box, and the letter the host takes out is the start of the alphabetical order. So, for example, if you start with the letter with Belgium, then the first letter in the alphabet is Belgium, and America will come later. And for precedence among representatives, I see that the slides are already a little bit quicker than I'm speaking, so I'll try to keep up with the slides. The precedence among representatives is, yeah, I can see it now. Yeah, the precedence among representatives. So that the representatives, I mean, it means the diplomatic representatives at a meeting. The precedence among the heads of states, so like the presidents or the king or queen. The order, firstly, is the order they took office. For example, if someone has been in office 20 years, he takes precedence over someone who has been in office for 10 years. Then it is their age. So basically, the more senior their age, the higher the precedence. And by drawing lots, again, also based on the alphabet. These three ways are chosen strategically to see, okay, who would sit next to each other for business and political reasons. And precedence among diplomatic representatives in the sense of like ambassadors, it's the date and time of presenting the credentials or of taking office. And the last thing about the precedence, so the order based on rank, about the United Nations member states. It's always done by alphabet. United Nations members are written in English or French, and the African Union uses the same United Nations scheme, so everything written in English or French. The European Union uses a little bit the different system. They also do it by alphabet, but they use the native language. So basically, Finland is called Finland in English, but in their own Finnish language, it means Suomi. That means it is the S that matters, not the F. And I see already the slides for the flag protocol. So there's now like about a dozen slides about flag protocol, which is quite colorful. So it's nice. It was nice to make. Yeah, flags, of course, are very important to present and to host, to present the countries that are participating in an event. The rules for the placement of flags and how they should be hung is always dependent on the perspective of the audience. And all flags are always at equal height and of equal size because all states are considered equal. So the flag of the United States is the same height and size as that of the Netherlands or South Africa, for example. For flags in line, when flags are placed in line, they are arranged alphabetically from left to right. So here you see an example of Brazil, China, France, South Africa. So it's simply the English alphabet. It is a bit different when a state hosts an event. for example, here I have took the example of South Africa hosting an event. Basically, that South Africa is there are a group of nations who will come to South Africa for an event. Basically, South Africa is then the guest of honor, and in the lineup of an uneven number of flags, the flag of the host country, the flag of honor, is always at the center. So you can see here I put South Africa as example. South Africa is then in the center, and then Brazil and China on the left and right. But if there is an even number of flags, then the host's flag is on the left, and then after the flag, it is again alphabetically arranged. The flag of honor. The placement of the flag always depends on the perspective of the audience. And so you look at the flag, you look at the audience, and then determine where the flag should be placed. Here you can see the flag should then be placed on the left side of the audience. In the next slide, it says flags leading up to a building, which also, of course, happens quite a lot when dignitaries go to another country. Yeah, can you go a bit up, please? Yeah, flags leading up to a building. There you can see that the flag of honor, again, here is South Africa. I used this example. South Africa is inviting other nations. Then the first flag will be the South African flag, leading up to the building. And then also when you go out the building, first the flag of honor and then the other flags based alphabetically. Of course, if there is no flag of honor, so for example, there's an event where there's no host, for example, at the United Nations, then there you just organize flags based on the alphabet, and you put them like you see here on the screen. Yeah, I hope you see this. Yeah, the screen is doing funny things for me here, but and then flags in a semicircle. I hope you can see that as well. The flag of honor, again, South Africa is inviting other nations for an event. The flag of honor is then in the middle. And then the second flag here, Brazil, was the B is in the English alphabet, of course, the first one, and then China, third, France, and then Japan. In this way, yeah, you can see it. A few more slides about flags. Flags outside the stadium. I hope you can see it because I can see it, but there are a few. Yeah. Okay, it's flags outside the stadium. The flag at the entrance of a stadium is the flag of honor. So again, South African flag, and the other flags are arranged alphabetically in a circle around it. But inside the stadium, it is the flag. So the flags now are inside the stadium, and then the flag of honor, South African flag, is here across the entrance of the stadium, and the other flags are again arranged alphabetically in a circle. The flag canton. Yeah, a few more colorful slides, and I hope the system will understand it. The flag canton. The canton of the flag is the upper left quarter of the flag, as you can see here, and use the US flag as a simple example because basically the canton is here, the stars, and then you have the stripes for the rest. When you hang it horizontally, everyone probably knows how to hang a flag. It should be oriented with the canton closest to the top of the pole. When you hang the flag vertically, things can start to become a little bit more complicated. It should be rotated with the canton closest to the top of the pole. I have here, can you go up, please? Or down, of course. Yeah. For the vertical flag. Yeah, thanks. One more. And here in the next slide, yeah, that's not unfortunately, because this was like a question. Well, which option is correct for the South African flag? Because this is something that people do wrong quite often. Yeah, the screen is unfortunately a bit chaotic because of the way it's presented, of course, on the mobile phone. But if you go to the vertical flag, the next one, then you see the South African flag, and then there are two options, option 1 and option 2. It's basically the question, which option do you think is right? You already saw the answer, unfortunately, quickly, but maybe you missed it but what do you think would be the best option? Would it be option 2 or would it be option 1? And yeah, well, it's not really a quiz question anymore because you can see it. Well, it's option 2, and because of course you have to look at the canton, and then that canton has to be on the top of the pole. Yeah, I had another. Well, maybe this one will work. I have option for the Kenyan flag, the flag of Kenya. There's also two options. Yeah, which one do you think would be the best option? Option 1 or option 2? Yeah. Yeah, can you go down? Yeah. Yeah. Well, I'll just continue then. So yeah. Yeah, for the Kenyan flag.
I'm actually browsing through my iWatch, so I'm actually doing that through my iWatch. So if you tell me if you mention the topic, it's easy for me to scroll there for you.
Okay. Yeah, can you go back now to like flags on cars? It's yeah. Yeah, thank you. Yeah, flags on cars. Yeah, you see two pictures of cars. The flags on a car is also always placed on the side of the car where it drives. For example, if you drive on the left-hand side, then the flag is put on the left hand. If you drive on the right-hand side, like in the US and Europe, you put it on the right side of the car. And for a flag on the podium, the flag is always on the right side of the speaker from his perspective, and just behind him or her. Yeah, this was the part of the nice pictures, and unfortunately, of course, with the problems with the slides, maybe it was a bit mixed up. But the next part is about international organizations and international law. I divided it up in 4 parts. First, shortly, the international system, then briefly how the United Nations works, and then more extensively about international law and international courts like the ICJ and ICC, and the councils and committees like Human Rights Council and Human Rights Committees. The next slide is about the international system. Yeah, I won't go too deep into it because we did a lecture on the international system. Well, you know that the international system is based on sovereign states without an overarching authority. So the balance of power ultimately governs the international system. Yeah, we have currently 195 states who are all sovereign and have exclusive authority to govern themselves. That means there is no intervention by other states possible. And the next slide is about international organizations. So basically there are two types of international organizations. You have the intergovernmental organizations, which is an organization composed primarily of sovereign states or of other intergovernmental organizations. They are established by a treaty or another agreement that acts as a charter creating that international organization. Example is, of course, the United Nations, but also like the World Bank, NATO, or the European Union. The second type is an international non-governmental organization. And ECOSOC, well, the United Nations Economic and Social Council, defines an international non-government organization as any organization which is not established by intergovernmental agreement, including organizations which accept members designated by government authorities, provided that such membership does not interfere with the free expression of views of the organizations. The examples of an international non-governmental organizations are the International Committee of the Red Cross and Médecins Sans Frontières. And the next slide. Well, you remember from the last lecture, I hope, that you have several versions of how to look at politics, and realism is by far the most dominant version of how to look at politics. Realism, the realist perspective on politics, basically also depends on high politics and low politics. It sees high and low politics. High politics is about peace and security, and it takes place in military alliances and UN diplomacy. Whereas low politics is about social and economic policies, and they take place in specialist UN bodies, other international organizations, and international NGOs. And in the next slide, you see an overview of high versus low politics. Yeah, when it comes to policy questions, high politics refers to peace and security, whereas low politics is concerned with social, economic, human rights, and environmental issues. And then the decision makers, the heads of government and senior ministers are the decision makers in high politics. So the heads of government, senior ministers, they deal with high politics, whereas junior ministers and officials are relegated to the remainder of the policies. When it concerns involvement, there is little involvement by NGOs possible when it comes to high politics, because basically senior ministers and decision makers. But there is extensive participation possible in social, economic, and other realms. And finally, about the type of situation, high politics is usually a high priority in times of crisis, and low politics is usually a low priority, and it's more routine and bureaucratic. And yeah, let's see the next slide also already. The liberal and constructivist perspective. Yeah, like I explained in the previous lecture, you have realism, liberalism, and constructivism. Liberalism and constructivism do not agree, of course, with the strict definition between high and low politics. Because, like here, it says, it ignores the interconnectedness and power dynamics between states and non-state actors. And that's, of course, the non-state actors are very important because civil society is often the source of social change, and companies are often the source of economic change. So you need to have them in the equation. Furthermore, of course, NGOs and international companies are specialists. And finally, capabilities do not determine influence. And I mean with that is, capabilities is like the resources under control. Like a state has many resources and capabilities, but it doesn't always use it that well. civil society has much less resources, but they can use it better sometimes than states. And the next slide is about issues and policy domains. An issue is a set of political questions that are related because they create a similar value conflict. For example, the issue of human rights creates a conflict between freedom and order. And a policy domain is a set of political questions that have to be decided together because they are linked by the political processes in an international organization. Sorry. An example is financial policies, which is resolved in the IMF. And in the next slide, you see here already on the screen, an overview of which political actors are involved in different policy domains. For example, the governments, transnational companies, UN Policy Forum, international NGOs, and international government organizations. For example, well, I won't do them all right now. That might take a bit too much time. But for example, the UN Policy Forum for Human Rights is then mostly the Human Rights Council. And for the environment, it's the high-level political forum on sustainable development. And
hey, Jerome, before you go to the next slide, maybe we want to pause for 5 minutes to say if students have some questions or some thoughts based on the very important component that you've shared so far, if that's okay with you.
Yeah, sure. And yeah,
great.
I hope you can follow us. Yeah.
All right, guys. So we've seen the discussions with regards to international protocol and what it entails. I know that some of you are having some difficulty seeing the screen because of my location. So what I have actually done is that I have actually posted the presentation on the platform. So each of you can actually have it on your side and you can review the session is ongoing. If you haven't received it, it will come. It's on its way coming. But then touched on some very important things that happens in international protocol. And if you want to be a diplomat, you ought to know them like assets. Some of the things we need to pay attention to immediately, like as he said, you get to a function, you should immediately know the diplomacy around how to greet, where flags are positioned, which country comes first. All these are diplomatic protocols followed. I don't know if some of you recall Donald Trump went to the Buckingham Palace to meet the Queen, and he was the first to give his hand to shake. That's against protocol. You don't shake the Queen's hand except she gives you a hand. So some of these things are very important. You may not see its usefulness, but they are very, very important and can create a lot of diplomatic blunder if care is not taken or if protocol is not well followed. And so at this point, if you have any question, any thought, any contribution, please, you are welcome to ask, and Jerome will gladly respond. Any question, any thought, any?
Well, there are many more slides to come, so they can ask questions later. I'm sure they will have more.
Yes. All right. So otherwise, we can continue so that we don't lose the time.
Yeah. Okay. Yeah. Secondly, I want to briefly describe the United Nations system. Yeah, the United Nations system, as you can see here, consists of principal organs, subsidiary organs, funds and programs, specialized agencies, and related organizations. Of course, the principal organs, the main organs of the United Nations are the General Assembly, Security Council, Economic and Social Council, the Secretariat, the International Court of Justice, and the Trusteeship Council. I'll briefly explain these a bit. Of course, the United Nations General Assembly is the main deliberative, policy-making, and representative organ of the United Nations, and it's responsible for the UN budget. It's also responsible for appointing the non-permanent members of the Security Council and appointing the UN Secretary General. The United Nations General Assembly is also the only United Nations organ wherein all member states have equal representation. So it's also very important for every member to reign. Secondly, you have the United Nations Security Council, which is charged with ensuring international peace and security, and also recommending the admission of new UN members to the General Assembly, and approving any changes to the UN Charter. Like I said in a few slides before, this is really the point of high politics. The high politics is in the United Nations Security Council. The Security Council consists of 15 members. 5 members are permanent: China, France, Russia, the UK, and the US. The great powers and the victors of World War II. They have a veto member. Those members have a veto on any resolution. And the other 10 members are elected on a regional basis for a term of 2 years. And then the third is the Economic and Social Council. In the realist perspective, that would be low politics, but I would also say that it's also quite high usually. So ECOSOC is responsible for coordinating the economic and social fields in the United Nations, specifically in regards to the 15 specialized agencies, 8 functional commissions, and 5 regional commissions. It is the central forum for discussing international economic and social issues and formulating policy. And it has 54 members. And the fourth principal organ is the United Nations Secretariat, which is the executive arm of the United Nations, and it carries out the day-to-day work of the UN as mandated by the General Assembly. The Secretariat has a very important role in setting the agenda for the deliberative and decision-making bodies of the United Nations, like the General Assembly, Economic Social Council, and Security Council, and also the implementation of these decisions. The Secretary General is appointed by the General Assembly, and he is the head of the Secretariat. And the fifth principal organ, which is also very important, we'll come back to that very extensively, the International Court of Justice. The International Court of Justice settles disputes between states in accordance with international law and gives advisory opinions on international legal issues. The ICJ is the only international court that adjudicates general disputes between countries, with its rulings and opinions serving as primary sources of international law. And then the sixth principal organ is the United Nations Trusteeship Council, which is now no longer operational, but it was established to help ensure that trust territories were administered in the best interests of their inhabitants. Those trust territories were usually former mandates of the League of Nations, already back in the early 20th century. It became defunct, so it stopped operations when Palau became independent in December 1994. So it's no longer functioning. And in the next few slides, I will not explain in too much detail what the specific organs do, but you have the subsidiary organs like the Disarmament Commission, the Human Rights Council, which is very important. And of course, other like International Law Commission, the Joint Inspection Unit, Counter-Terrorism Committee, International Residual Mechanism for Criminal Tribunals, the Military Staff Committee, Peacekeeping Operations and Political Missions, which of course Mr. Bird had a presentation about, and also some committees that were set up by the General Assembly. And then thirdly, you have the United Nations funds and programs. You have the UNDP, United Nations Development Program, United Nations Environment Program, United Nations Population Fund, UN Habitat, UNICEF, Children's Fund, and the World Food Program. And then you have the specialized agency. You see here a list on the screen of the specialized agencies of the United Nations, like the IMF, UNESCO, and the World Health Organization. And then the fifth pillar is the related organizations, like the OPCW and the World Trade Organization. And then in slide 48 with me, it's an overview of the United Nations system. So all the things that I just showed you, it's probably in too small letters to see on the screen, but on the left side, you have the principal organs, and then one step further, you have 1, 2, 3, 4, 5. Yeah, it's subsidiary organs. So in one overview, you can see the UN system. And while you have the presentation, so I hope you can also see it from your own screen. My screen is doing strange things. And yeah, I want now to go to the funding of the United Nations. So that's the slide after the United Nations. Would it be possible to, yeah, the funding of the United Nations. Yeah. Yes, so the next, I think 5 slides provide an overview of the United Nations funding. This information can also be found on the United Nations website, and then you can filter out where the funding is coming from and where it is going. The first slide, well, you can see that the budget of the UN is approximately $60 billion. But you can also see that the majority of the income comes from voluntary contributions, because only the part that is in blue is mandatory. And the second slide shows the budget of the various UN entities. As you can see, most of the mandatory funding goes to peacekeeping. So, yeah, it's visible on the screen. So most of the funding goes to mandatory funding goes to peacekeeping and the UN system. And whereas, for example, the World Food Program and World Health Organization and UNHCR, they rely mainly on voluntary contribution, which you can see on because of the red bar, which the red bar means that it's voluntary. The next slide, it's also very enlightened. It's the top 10 donors, so the countries that give the most to the United Nations. You can, for example, you can see that the United States provides as much funding to the United Nations as all the countries outside of the top 10. And the rest of the top 10 donors are European countries and China and Japan. And of course, it's always important to see who is funding what, because most of the funding to the United Nations is voluntary. So it also depends on where people so the policy of the United States is yeah. So the screen is doing something. But yeah, it's important because then you can also prioritize the activities of the United Nations. If there is no money, there is also no activity possible. So it's very important who donates and where they donate, because countries can determine themselves where they provide their budgets, so the voluntary part. And because that's most of the money that goes to the United Nations, so it's very important what the priorities of the specific countries are. And the following slide, yeah, you already see this slide, is the top 10 non-government donors. You can see the European Union. It's of course it's a union of states, but still it's a non-government donor. And you can also see that private funds like the Bill and Melinda Gates Foundation, they provide more than $400 million per year. So they are one of the main funders of the World Health Organization. So you can see if that money was not available, then the World Health Organization would be not able to do what they were doing right now. And next slide, please. Yeah, this slide. And I want to move on to international law. Yeah, thank you. Yeah, in the remainder of the lecture, I want to explain the international legal framework. First, a very short introduction on international law. Well, international law is the set of rules, norms, and standards recognized as binding between nations. The sources of international law, according to Article 38 of the Statute of the International Court of Justice, are the following: international treaties and conventions, international customs as derived from the general practice of states, and the general legal principles recognized by civilized nations. Yeah, in the next slide, you can see international law versus state-based legal systems. International law differs considerably from national law. International law applies to countries, whereas national law applies to individuals. And the second major difference is that international law is based on consent, whereas national law is based on enforcement. Consent means that states need to approve their prosecution, which is of course very different than the way the national legal system works. For example, in a national setting, if two neighbors disagree on the boundary line that separates their property, one neighbor can bring a lawsuit against the other. The neighbor who files the lawsuit does not need to obtain the consent of the neighbor. But at the international level, the situation is different because states are sovereign entities. States are the highest power and authority within their territory, and they therefore cannot be subject to any higher authority without their consent. So this is, in very brief, this is the main difference between international and state-based law. International law applies to countries and is based on consent. State-based law applies to individuals and is based on enforcement. And in the next slide, the history of international courts. Law and justice have been on the mind of people for many centuries, but I will focus on the birth of the international legal systems and legal instruments we have today. Important questions are, why did people start thinking about creating international courts? What global values did they intend to protect? Why do we need international courts anyway? And what was the first global value? And yeah, you see the next slide, the Hague Peace Conference of 1899 and 1907. The roots of the current international legal order lie in 1899 at the International Peace Conference in The Hague. The first Hague Peace Conference was convened in 1899, and the second one was held in 1907. Together, these Hague Peace Conferences set the stage for international diplomacy and for international relations between states as we have them today. The Hague Peace Conferences were foundational for the system of international dispute settlements that we currently have. But it's also important to realize that this system was designed by only 26 European nations. The political motivation to convene this peace conference was to halt the process of building ever larger armies and to alleviate the financial burdens that came along with building those armies. Hence, the central themes of the two peace conferences were 1, disarmament, and 2, peace. So you can say that those were the first global values. The Peace Conference also established the Permanent Court of Arbitration, which we'll discuss later on, which is also located in The Hague. In the next slide about dispute settlement, I wanted to focus a bit on what other options are there besides international courts to settle international disputes and to protect global values. In general, we distinguish between diplomatic methods and legal methods. For the first type of dispute settlements, the diplomatic method, diplomacy and negotiations are central. Whereas for the second type, the legal method, the law plays a decisive role. In negotiations, there is no third party involved. No negotiations are purely bilateral between two parties involved in a dispute. The most common legal method is judicial settlement by third party, namely a court. In between, we find a range of other methods where a third independent party plays a role. This third party can be a person, state, or the United Nations. The decision of a third party can be an advice or it can be binding upon the parties. Diplomatic methods that go beyond negotiations because they include an independent third party are mediation and conciliation. So those are the diplomatic methods that go further than just negotiation, because negotiation is always between two parties, whereas this is with an independent third party. A mediator can intervene in a dispute by assisting in negotiations and even proposing solutions. Examples of individuals and institutions that have often mediated international disputes are like the UN Secretary General and the International Committee of the Red Cross. The second diplomatic method is conciliation, which is a more institutionalized form of mediation. It's often done in form of conciliation commissions. Recommendations of conciliation commissions are not binding on the parties, which underlines the diplomatic nature of this mode of dispute settlement. An example is of institutionalized conciliation in the context of human rights, is that in many regional human rights systems in Europe, America, and Africa, of course, also, individuals can launch a complaint against the state directly to an international court or sometimes to commissions. But very often in the procedure of these courts and commissions, there is first an obligation for the court or the commission to find a friendly settlement between the individual and the state. Such a friendly settlement does not need to be based on law and can thus be seen as a conciliation exercise. And in contrast to these two diplomatic methods, you have the legal methods. And the legal methods are based on law. The prime examples are arbitration and judicial settlement. The difference between these two, arbitration and judicial settlement, lies in the extent of control that parties to the dispute have. In both cases, the dispute is settled on the basis of law, but in case of arbitration, states can choose the arbiters. They can also choose the law and they can choose the procedure. Whereas in the case of judicial settlements by courts, these matters are all predetermined by the court itself. In many present-day treaties, we often see a mixture of methods, a combination of diplomatic and legal means. For instance, many treaties compel states to first endeavor to settle their disputes about a treaty through negotiations first, and only if this has proved impossible, then do these treaties indicate that this dispute should be referred to the ICJ or to arbitration. And before we move on to the next section about the various courts, I want to outline the main international legal questions and challenges. The international legal challenges. These are law and politics, state consent, and global values. On law and politics, the attempt to subject interstate relations to an international rule of law. Do international courts operate independently from states? How does the design of courts facilitate their independence? And on state consent, States cannot be bound by international law against their will. How does state consent influence the potential of courts to settle disputes, develop the law, and protect global values? And finally, on global values, there are three main areas. Firstly, the protection of the global commons, like the oceans, the atmosphere, outer space, cyberspace, and the Arctic. Secondly, the protection of shared interest, like the protection of the environment and the promotion of public health. And third, the protection of abstract values, like peace and justice. And yeah, in the next slide, I hope you can see that. It's I'm going to have an overview of 4 different courts and councils. Firstly, we're going to discuss the International Court of Justice, which is a UN principal organ, then the International Criminal Court, UN-related organization, then Human Rights Council, UN subsidiary organ, and then the Human Rights Committee, which is not related to the United Nations, but it's in fact a treaty body. So it's reliant on the treaty, and it's only the UN only helps with administration. Yeah, first, the International Court of Justice. Well, you see here the picture of the Peace Palace. The International Court of Justice was established in 1945 by the UN Charter and started functioning in 1946. According to the UN Charter, the ICJ, International Court of Justice, is the principal judicial organ of the United Nations. This means that the ICJ is the UN's only permanent court available to states that want to settle their disputes peacefully. The court has the capacity to resolve disputes concerning a very wide range of issues, because this is how the drafters of the UN Charter designed the court. Since 1946, the court has settled disputes about land and maritime border boundaries, about the use of force, genocide, use of nuclear weapons, protection of the environment, and the immunities of high-level government officials and also states themselves. The ICJ can be considered the successor to the Permanent Court of International Justice, which was established in 1920 and was associated but not part of the League of Nations. The Peace Palace in The Hague served as the home of the Permanent Court of International Justice. It is now the home of the ICJ. And of course, the Permanent Court of International Justice was dissolved after the Second World War. The Permanent Court of Arbitration, which is also housed inside the Peace Palace. Well, we come to that later. About the ICJ, the International Court of Justice. The ICJ is composed of 15 judges, and they are elected to 9-year terms by the UN General Assembly and the UN Security Council from a list of people nominated by the national groups in the Permanent Court of Arbitration. No 2 judges may be nationals of the same country. And also, according to Article 9, the membership of the court needs to represent the main forms of civilization and of the principal legal systems of the world. And this means the representation of common law, civil law, and socialist or post-communist law. There's also an informal understanding that the seats will be distributed by geographic regions, so that there are 5 seats for Western countries, 3 for African states, 2 for Eastern Europe, and 3 for Asian states, and 2 for Latin America. And then the next slide is about the jurisdiction. When does the International Court of Justice have jurisdiction? Disagreements between states are inevitable and they arise frequently. And they, of course, they are a normal part of international relations, just like they are in normal life. For example, neighboring states may disagree about the course of the land or maritime boundaries that separate them. The states are free to choose how they would like to settle their disputes in a peaceful manner. and sometimes they conclude that the best way to resolve a dispute is through the International Court of Justice. After negotiations have failed or they have reached a stalemate, states sometimes decide to entrust the resolution of their dispute to a third party like the ICJ. But in order for the ICJ to be able to decide a dispute between two states, both of those disputing states have to consent to the court settling their dispute. In other words, both states must voluntarily submit their disputes to the court. States cannot be forced into litigation at the ICJ against their will. So basically that means if one state consents and the other does not, then the ICJ has no jurisdiction. The term jurisdiction means that the court has the competence to decide the case before it. Both parties to a dispute must be willing to submit this dispute to the ICJ. They need to consent with the dispute. This is for very good reasons, because of course you know that states are sovereign entities and the highest power or authority within their territory, so they cannot be subject to any higher authority without their consent. States cannot be forced to subject themselves to the will of any other state, and nor of an international court or international organization. The need for consent can also be explained on a more pragmatic level because of the ICJ's inability to enforce its own judgment. The judgments of the ICJ are binding on the parties to a dispute, and the litigants are obliged to comply with the ICJ's decision, but, which is very important, the court cannot rely on the international police force to enforce its judgments because there is no such force. Compliance with the court's judgment depends on the willingness of states to resolve their disputes. The way they do this, states can reach a mutual agreement to bring a dispute to the court. And this mutual agreement is called a compromis in French. And these agreements give the ICJ jurisdiction over them on a one-time basis with respect to an existing dispute. In other words, states conclude special agreements after a dispute has risen. States can also consent to the court's jurisdiction over disputes that may arise in the future. States can conclude treaties that contain provisions that give the ICJ jurisdiction if a dispute arises about the treaty's application or interpretation. So basically, the state consents, gives its consent through this treaty that the ICJ has jurisdiction when a dispute arises. Besides the legal actions that the ICJ can do, there is also the advisory role. The ICJ has an advisory jurisdiction. Most of the court work involves settling dispute between states, but the court also provides advice to United Nations bodies on legal questions. A number of these advisory opinions relate to highly controversial and political issues, such as declarations of independence and nuclear weapons. From time to time, the UN's political organ can benefit from authoritative advice on legal issues that arise during the course of their work. Both the General Assembly and the Security Council tend to encounter problems of international law. The drafters of the UN Charter anticipated that these political bodies would sometimes need authoritative legal advice. The Charter, therefore, UN Charter, allows the General Assembly and Security Council to outsource their legal advice by asking the ICJ to give an advisory opinion on any legal question. The UN specialized agencies, such as the World Health Organization and the International Labour Organization, can also request advisory opinions, but they need to be authorized to do so by the General Assembly, and only when the request falls within their mandate. States, however, cannot request an opinion from the ICJ, but they can draft questions and participate in advisory proceedings. And yeah, advisory ICJ opinions Technically speaking, the court's advisory opinions do not bind the UN bodies that request them, so they are not binding. In practice, however, these opinions are considered highly authoritative, and they contribute to a better understanding of international law with respect to issues like unilateral declarations of independence. In addition, the requesting body can decide to give such opinions a binding effect. For example, the World Health Organization can say that the opinion given by the ICJ is binding on what they wanted to, binding on themselves. Arbitration. Arbitration is one of the two legal means to settle international disputes, of course, together with judicial settlements, like we just said, between diplomatic and legal methods. Judicial settlement is characterized especially by the fact that the dispute is settled by a standing tribunal, like the International Court of Justice. Contrary to judicial settlements, arbitration is designed by the parties to the dispute. They can choose, for instance, the arbiters and the law applicable to the settlement of the dispute. However, there also exist permanent institutions that can assist arbitration tribunals in the settlement of disputes, which is the Permanent Court of Arbitration. The Permanent Court of Arbitration is an intergovernmental organization that was established in 1899 during the first Hague Peace Conference. More precisely, it was established by the Convention on the Pacific Settlement of International Disputes. This convention, together with the 1907 Convention on the Pacific Settlement of International Disputes that revised it, constitute the basic documents of the Permanent Court of Arbitration. The Permanent Court of Arbitration is older than the International Court of Justice. And it's even older than the Permanent Court of International Justice that was established in 1920. In fact, the Permanent Court of Arbitration is the oldest universal mechanism established to settle interstate disputes. The Permanent Court of Arbitration is located in the Peace Palace in The Hague, together with the ICJ. The Permanent Court of Arbitration, PCA, is, although it is named a court, is in fact not a court, at least not in the same sense as the International Court of Justice. The Permanent Court of Arbitration is a permanent administrative framework and not a permanent body with sitting judges which rule over disputes itself. The disputes that the parties have expressly agreed to submit for settlement under the auspices of the PCA are settled by ad hoc arbitration tribunals. This means that for each new dispute submitted, a new tribunal is appointed. The Permanent Court of Arbitration is facilitating the work of these ad hoc tribunals. The Permanent Court of Arbitration not only administers arbitration, but also conciliation and fact-finding. In addition to registry services, the Permanent Court of Arbitration also acts as an appointing authority of arbitrators. And you can see here that the services are provided by the Secretary General and the International Bureau that he leads, together with the Administrative Council and the members of the court. The Administrative Council of the Permanent Court of Arbitration is made up of the member states' diplomatic representatives accredited to the Netherlands. And they oversee the budget and the policy of the PCA. And the court is also made up of what is called the members of the court. Members of the court is composed of potential arbitrators who can be appointed by the parties to the dispute submitted to the PCA, but that doesn't have to be the case. And the next slide is the objects and parties of disputes. The objects of the disputes submitted for resolution at the Permanent Court of Arbitration are very diverse, as evidenced by past disputes. They relate, for instance, to territorial and boundary delimitations, human rights, commercial or investment issues. As to the parties, most of the disputes settled under the auspices of the Permanent Court of Arbitration are both states or a state and a foreign investor. So interstate investor-state disputes are the main cases. Interstate arbitration plays a crucial role in the settlement of interstate disputes today. This is the result of the control that it leaves to states over the settlement of the disputes. Because states retain a large control over how arbitration is conducted. First of all, state consent is always required in interstate arbitration. In other words, contrary to the function of the judiciary in the national legal systems, no interstate dispute can be settled by arbitration without agreement of both parties. Arbitration tribunals have no automatic jurisdiction over interstate disputes. The consent is usually given after a specific dispute has arisen between states or in a treaty with respect to future disputes that will arise from it. So basically, you give the consent with a specific dispute, or you give your consent by subscribing to a treaty where you give your consent. Secondly, contrary to the settlement of interstate disputes by International Court of Justice, states can decide who will act as arbitrator. They can determine the law to be applied to the dispute and to the procedural arrangements. And finally, they can also decide on the level of confidentiality. This includes whether the hearings will be open to the public and whether the decision will be released. So they can keep everything private. Investor-state arbitration is slightly different. It's also a newer process. Investor-state arbitration emerged during the 20th century as a substitute for national tribunals and diplomatic protection to settle the disputes between foreign investors and states. The main objective of the recourse to arbitration was to depoliticize the settlement of investor-state disputes, which were viewed as overly political. As a matter of fact, the domestic tribunals of all states were perceived as being biased and lacking independence for the benefit of the host states. As to diplomatic protection, the discretion of the exercise of this protection by the home states of investors, depending on their own interests, created unpredictability and insecurity for the investors. As a result, arbitration was increasingly incorporated into contracts concluded by states and foreign investors regarding specific investment preparations. And nowadays, investor-state arbitration is mainly used to settle disputes arising from bilateral and multilateral investment treaties concluded between states. There are currently more than 3,000 bilateral and multilateral investment treaties being enforced. These treaties grant rights to the investors of states that invest in another state party. These rights are the right to be treated fairly and equitably, the right not to be discriminated, and the right not to have their property expropriated without compensation. When an investor considers that his rights have not been respected and that the host state has breached its treaty obligations, it can bring a claim. It can do so because the parties themselves traditionally give their consent to the settlement of investor-state disputes through arbitration in the investment treaties itself. So they give their consent already in the treaties itself. In investment treaty arbitration, the consent of the parties to a dispute is not, I have to say it a little bit differently, but in investment treaty arbitration, the consent of the parties to the dispute is not given at the same time, which is very important. For example, in a bilateral investment treaty, two states give their consent in advance with respect to the investors of the other state party to the treaty. However, the investor gives their consent individually or collectively at a later stage when they submit their claims or their request for arbitration. It also brings me to the last slide on this part, the criticism on this method. While it is the main method used to settle investor-state disputes, there is a lot of criticism about this kind of arbitration. One criticism relates to the issue of consent. State parties to bilateral investment treaties give their consent to arbitration in advance with respect to all the investors of the other state party investing in that territory. And because foreign investors can then express their consent unilaterally, these investors can try to constrain the regulatory power of the state. They can threaten to initiate arbitration with respect to measures that negatively impact their investment, with the intent to have states withdraw or not to adopt these measures at all. And second criticism relies on the private nature of investor-state arbitration. The investor-state arbitration was modeled on commercial arbitration, which means that the procedures are confidential. For instance, the hearings are not public and the results are often not released. And now I want to go to the next slide. Can you go to the next slide, please? On the International Criminal Court. Yeah, okay, I hope it works. Yeah, I want to go to another international organization in The Hague, the International Criminal Court. I'm not. My screen is blocked. I only see the criticism slide.
Okay, because
yeah.
Yeah, Jerome, you can go ahead. Can you still see? Because
no, I cannot see. Well, I see the slide of criticism. That's the slide I can see, but the other slides I cannot see. But maybe other people can see it. But okay, I can go ahead. Yeah,
yes,
because
just go ahead.
Okay, now I want to turn to another international organization in The Hague, which is also very important, the International Criminal Court. Now I can see the slides. Thanks. Yeah. The focus of this part with the International Criminal Court, which is also called the ICC. The ICC, located here in the Netherlands, not in Peace Palace, but still in The Hague. The ICC is the first permanent international criminal court, and it has universal aspirations. I will start with some reflections on the origins of international criminal courts and on the relation with international criminal law in the 1990s. I intend to give you some insights into the family of international criminal courts and tribunals and the foundations of the ICC. At the same time, I want to give a historical perspective to enable you to contrast the ICC with its predecessors and to spot differences between the different courts in the different eras. At the end of this part of the lecture, you will understand the three differences between the ICC and the Nuremberg Tribunal, and of course other tribunals as well. But the Nuremberg Tribunal, you probably all know, it was the tribunal to after World War II tribunal for the Nazis in 1946. Where does the future of international criminal law lie? Does it lie with the ICC, with domestic courts, or perhaps with regional courts. Yeah, the history of the international criminal law. Examples of criminal trials with international feature date back for centuries, but I won't go into that. I will just focus on the most immediate forerunners of the ICC, which is the Nuremberg Tribunal. As you will know, this tribunal was established after the Second World War to deal specifically with Nazi crimes. The central charge concerned the waging of aggressive war, also called the crime against peace. The Nuremberg judgments are still influential today, and they thus constitute important precedents. Nonetheless, the greatest criticism voiced against the tribunal, the Nuremberg Tribunal, was that they are a symbol of winner's justice, because they prosecuted only one side and left crimes of the Allies unaddressed. After Nuremberg, there were a number of sporadic trials at the domestic level in national courts, like the Eichmann case in Israel in the early 1960s. But apart from these exceptional cases, international criminal law largely lay dormant until the early 1990s. In the next slide, it's in response to the conflict in the former Yugoslavia in the 1990s, the UN Security Council decided to establish ad hoc the International Tribunal for the former Yugoslavia, ICTY. 1 year later, a similar tribunal was established for Rwanda to make up for the international community's failure to act during the 1994 genocide. This tribunal was called the International Criminal Tribunal for Rwanda, ICTR. The ICTY, Yugoslavia Tribunal, was based in The Hague, while the Rwanda Tribunal, the ICTR, was based in Arusha, Tanzania. The two ad hoc tribunals were established ex post facto, meaning after the crimes had already been committed, similar to the Nuremberg Tribunal. They also possessed limited jurisdiction in geographic and temporal terms, which means that only crimes committed in a specific area and time frame could be prosecuted at these tribunals, the ICTY and ICTR. Yet the substantive jurisdiction, so the crimes prosecuted at the ad hoc tribunals, differed from thereafter. Aggression, also called the crime of peace, crime against peace, was not part of the crime catalogue as was in the Nuremberg Tribunal, but genocide, crimes against humanity, and war crimes were. In fact, genocide was a central charge in most, if not all, the ICTR cases, while many ICTY indictments featured persecution as a crime against humanity. One important heritage emanating from both tribunals regard their attention to sexual violence and gender-based crimes, which were ignored in Nuremberg. For example, in the Akayesu case, the ICTR held that rape could also be a genocidal act. Landmark cases on sexual violence at the ICTY are, amongst others, the Vrumcha case and the Kunarac case. The ad hoc tribunals, ICTY and ICTR, they were established by the UN Security Council, and the Council did so acting under Chapter 7 of the UN Charter, which is very important because Chapter 7 of the United Nations sets out the UN Security Council's powers to maintain peace, and it allows the Council to determine the existence of any threat to the peace, breach of the peace, or act of aggression, and to take military and non-military action to restore international peace and security. This is so important because decisions made under Chapter 7 are binding in all UN member states. This means that the tribunal was imposed on the territorial states where the crimes had been committed. So the states of the former Yugoslavia and Rwanda were obliged to cooperate and accept the tribunal. And even beyond those two countries, or those former countries, all the UN member states had an obligation to cooperate with the ICTY and the ICTR. This means that all states have a duty to surrender suspects if asked to do so and to share evidence. These tribunals, the ICTY and ICTR, were unique because the international system is based on consent, whereby states decide if they consent with the jurisdiction and if they wish to cooperate. But the mandatory regimes of the ICTY and the ICTR are therefore very exceptional because they did away with consent and obliged everyone to cooperate. In the following years, the debate on what the goals of international criminal justice should be intensified. According to the 2004 Rule of Law report by the Secretary General of the UN, these goals are, and I have here a list, bringing those responsible for serious violation of human rights and international humanitarian law to justice, putting an end to such violations, preventing their recurrence, securing justice and dignity for victims, establishing a record for past events, promoting national reconciliation, re-establishing the rule of law, delegitimizing extremist elements, and contributing to the restoration of peace. So you see there are a lot of ideals. But in the next slide, you have the hybrid tribunals. In the 1990s, after the establishment of the ICTY and the ICTR, the international community also experimented with so-called hybrid tribunals. These are, here I have two examples, the Special Court for Sierra Leone and extraordinary chambers in the courts of Cambodia, or the Khmer Rouge Tribunal, which is still in effect. These tribunals mixed the international with the national in terms of the applicable law and the individuals involved in the proceedings, particularly the judiciary. And in the next slide, the differences between the ICC and the Nuremberg Tribunal. The ICC ex ante, or ex ante means before the event, and ex post factum means after the event. So you can see this. These are the main differences. The ICC is jurisdiction before the event. It has potential universal application and is permanent, whereas like tribunals like the Nuremberg Tribunal was after the event, only had limited application, only to Nazi crimes, and it was temporary. In the next slide, it's an overview of the establishment of the ICC. The ICC was established following intense negotiations in 1998 in Rome, and eventually on the 17th of July 1998, 120 states adopted the statute for an international criminal court. That's why it's also called the Rome Statutes, because it was adopted in Rome. So it was adopted in 1998, but it was ratified on 1 July 2002 when 60 states ratified the Rome Statute. The court currently has the jurisdiction to prosecute 4 crimes. These are firstly genocide, crimes against humanity, war crimes, and aggression, crime of aggression. Aggression as an international crime is, in short, a severe violation of the use of force against another state. Unlike the ICTY and the ICTR, the ICC has universal aspirations. It's not just permanent, but it's also meant to be a court for the entire international community. Given its global potential, states were very wary to keep the ICC under their control during the negotiations in Rome. Consequently, the institutional design of the ICC, being treaty-based, has more features of a consensual system. Unlike the Chapter 7-based tribunals for Yugoslavia and Rwanda, the ICC is not binding on all member states, but in principle only on those states which have become a party to the statute. Which this is, of course, a very important point. Like ICTY and ICTR, they were Chapter 7 based tribunals, meaning the UN Security Council gave the tribunals a mandate that was binding on all UN member states. The ICC, however, is not binding on all UN members, only to the ones who became party to the statute. Despite aspirations to anti-impunity, states did not provide the ICC with universal jurisdiction. So the ICC cannot prosecute any international crime committed wherever by whoever. But instead, the reach of its jurisdiction is limited. The principles upon which the court functions are the territorial principle and the active nationality principle. You can find this in Article 12 of the ICC statute. According to these principles, the court can only prosecute crimes committed on a territory of a state that is a party to the Rome Statute, or crimes committed by a national of a state party. And furthermore, only the UN Security Council can extend the jurisdiction of the ICC beyond Article 12. And for example, in the next slide, I have an example. The ICC cannot prosecute crimes committed on a territory of state that are not party to the ICC statute and which are committed by nationals of that state. This means, for example, that many of the crimes committed by warring factions in Syria and Iraq cannot be prosecuted by the ICC, since both of these states are not parties to the ICC statutes. However, the ICC prosecutor can prosecute foreign fighters or nationals of state parties. And the next slide, please. In those situations in which the ICC does have jurisdiction, the next question is how these situations may be brought to the court. So how do you get the situation to the court? This concerns trigger mechanisms. This is the method on how the ICC's jurisdiction can be activated. There are three such mechanisms. There are three trigger mechanisms which are laid out in Article 13 of the statute. These are referral by a state, referral by the Security Council, and proprio mutuo action by the ICC prosecutor. The most traditional trigger mechanism is a state referral, which we can find in Article 13a. These were also the first situations that came before the court. Yeah, I can see it now. Yet in these situations, the trigger mechanism of state referrals was applied in a very creative manner. As the ICC prosecutor, in a way, encouraged states to refer their own situations. So that's why I call it also self-referrals. And well, you have a few examples. You have the DRC, you have Uganda, Central African Republic, and Mali. So basically, the governments themselves, the ICC asked, they asked the ICC. So this was like a self-referral. The second trigger mechanism, Article 13b of the ICC statute, is that situations can be referred to the ICC by the UN Security Council. This trigger mechanism, comes into play when the Security Council determines that there is a threat to the peace, which can best be addressed through ICC prosecutions. Importantly, also, the Security Council can also refer situations of crimes committed in states that are not a party to the ICC statute. Only the UN Security Council can do this. That means also that the Security Council can extend the ICC jurisdiction and, in theory, give it global reach. However, of course, you have the issue of the veto members in the Security Council, which limits this possibility. And finally, of course, the prosecutor can act when he or she decides to initiate an investigation on his own, without the state or the Security Council prompting to do so. However, there is a restraining element. The office of the prosecutor can only open investigations into a situation if it has received authorization by the pretrial chamber. And that one is usually not that easy. And a last fundamental feature of the ICC, which reinforces its consensual basis, is the principle of complementarity. The ICC is complementary to domestic jurisdiction. Complementarity is a better way to organize concurrent jurisdiction between the ICC and domestic criminal courts. In this respect, states, they keep the primary responsibility to investigate and prosecute international crimes. The idea of complementarity is laid down in Article 17 of the ICC statute and involves a two-step analysis. The first step is to determine whether there are or have been investigations or prosecutions. If not, then the court has automatic jurisdiction. The second step is made if there are domestic investigations and prosecutions. And in those situations, the court has to determine whether domestic authorities are unable or unwilling to do so. And this is a more complex assessment. For the assessment of complementarity, the court has developed the same person, same conduct test. This test determines that the ICC will not interfere if a person is being or has been investigated or prosecuted at the domestic level for the same conduct. So if a person is being prosecuted for corruption at the domestic level, this does not bar ICC action. But if a person is prosecuted for the same conduct at the domestic level, then the ICC case is inadmissible and that cannot proceed. I think we lost the presentation. Hello?
Yes.
Yeah.
You lost me?
Yeah, but I now see you again, but the presentation, yeah.
So let's see.
We're almost finished. It was slide 87. Slide 87. Yeah, not a little bit up.
Yeah, the principle of complexity.
Complementarity, yeah. Complementarity, yeah. Yeah, it's now almost finished. So, yeah, where was I? Challenges. Yeah, about complementarity. Yeah, just to finalize, when is a case substantially the same? Well, when there's a lot of overlap between the domestic and the ICC investigation. And then the last slide on the ICC. The ICC has encountered some very important challenges. The first challenge is the lack of enforcement power. The ICC does not have its own police force. It is dependent on state cooperation to execute its arrest warrants, but also to be granted territorial access to undertake its investigations of the crime scenes and to interview witnesses. The second challenge relates to the intervention in ongoing conflicts. Some of the situations under ICC scrutiny concern ongoing conflicts. Of course, it's clear that this complicates the ICC prosecutor's work, also politically. And the third challenge is the high or maybe too high expectations the expectations of ending impunity, redress of victims, and fostering national reconciliation. The ICC cannot solve and address everything on its own. So, but the fourth, it might be the biggest challenge of the ICC, is the critique of selectivity, of applying double standards, and of being Africa focused, since most of the cases involved African nations. However, in most African situations, the ICC intervened at the request of the state itself, because it thought that its own legal system could not handle these things. And that was, yeah, the part on the ICC. And now I have a few slides on the Human Rights Council and the Human Rights Committee. The Human Rights Council, yeah, it was established by the United Nations General Assembly on 15 March 2006. It's a United Nations body whose mission is to promote and protect human rights around the world. It has 47 members elected for staggered 3-year terms on a regional group basis. This means that the seats are distributed among the United Nations regional groups, 13 for Africa, 13 for Asia, 6 for Eastern Europe, 8 for Latin America and the Caribbean, and 7 for Western Europe and others. The headquarters of the Council is in the UN office in Geneva, Switzerland. And the Council investigates allegations of breaches of human rights in United Nations member states and addresses thematic human rights issues like freedom of association and assembly, women's rights, and the rights of racial and ethnic minorities. The Human Rights Council has well, 5 subsidiary bodies, or grouped into 5 subsidiary bodies. Firstly, the subsidiary bodies, and then subsidiary expert mechanisms, the forums, and then the working groups and special procedures. The subsidiary bodies, the Universal Periodic Review, the UPR. It's a periodic review of the human rights record of all UN member states. So every member state is reviewed in a cycle of 7 years on their human rights record. Secondly, you have the advisory committee, which consists of 18 experts that function as a think tank for the Council and work at its direction. It meets twice a year, for 1 week in February, immediately before the March session of the Council, and also for 1 week in August. And another subsidiary body is the complaint procedure. It addresses communications submitted by individuals, groups, or non-governmental organizations that claim to be victims of human rights violations, or that have direct, reliable knowledge of such violations. So this is something that realists would say is low politics, but you can still have quite a lot of influence. Yeah, maybe I should go because it's already quite late. Yeah, the next slide is an overview of the subsidiary expert mechanisms and forums. While these expert mechanisms provide the Council with thematic expertise, and the forums provide a platform for dialogue and cooperation. These focus mainly on studies, research-based advice, or best practices. They meet and report annually to the Human Rights Council. And here we have a list of these mechanisms: the expert mechanism on the rights of indigenous people, expert mechanism on the right to development, and then the various forums. And fourthly, you have the open-ended intergovernmental working group. And these working groups are there to elaborate and negotiate on new draft legal instruments, or to make recommendations on the effective implementation of existing instruments. And here you have an overview of the various working groups. And finally, the special procedures. Well, the special procedures are actually not procedures, but independent human rights experts with mandates to report and advise on human rights from a thematic or country-specific perspective. They have a 3-year term, and as of now, there are 45 thematic and 13 country mandates. And yeah, then I can see it's already on screen. Yeah, here you see the list of treaty bodies. But I think no, it's too much for because I took out quite a lot of the presentation, so I think that'll be good. But I just want to say a little bit about the Human Rights Committee, because the Human Rights Committee is something different than the Human Rights Council. The Human Rights Committee is not part of the United Nations. The Human Rights Council is a UN political body, and officially the Human Rights Committee is an organization established by a treaty. It's a treaty body established by a 1966 Human Rights Treaty, International Covenant on Civil and Political Rights. And 10 years later, in 1976, this entered into force when 35 states had finally became parties to it. The Human Rights Committee is a UN expert body, although it's not a UN organization, it's still called a UN expert body. It's a bit strange, but that's how it works, consisting of 18 experts. It is administratively supported by the United Nations. It meets 3 times per year, and it only discusses matters related to the treaty. And all states party to the treaty have to submit reports on the measures they have adopted, which give effect to the rights recognized in the ICCPR and on the progress made in the enjoyment of those rights. And NGOs and individuals can submit complaints as well. So this also means that all the states that are party to this treaty are obliged to follow the human rights standards by this treaty, which of course is also different from the Human Rights Council, which is based on consent. And I think that's the last of the slides I have for you today. Yeah, I think the main issue, of course, was like diplomatic protocol, but also the international legal organizations and how they